There's nothing more thrilling than nailing an insurance company.
And the truth shall set you free!
I want the truth! You can't handle the truth!
Great moments are born in great opportunity.
Today we're joined by Sean McCleary, and we want to thank him for coming on board. For those that don't know, Sean's an associate in the Tampa office of Bartlett Loeb. He works primarily, and I'm going to probably fuck this up, but doing commercial litigation, representing plaintiffs like individuals and businesses who have been wronged, prosecuting claims, dealing with fraud, RICO-related stuff like that, and a whole other assortment of tangential claims. But that's not where he began. Sean began at the University of Miami School of Law, just like John and I, so go Canes. We don't fault Sean for graduating from UF in undergrad. We'll just ignore that fact. But Sean joined us today because he has an interesting perspective to share about a lot of different things, not the least of which is he began his career the first 5 or 6 years down in Miami, down in South Florida like John and I, but he was on the opposite side of injury and wrongful death claims. He was doing the insurance defense stuff. And after doing that, he got some exposure to commercial, found himself a good mentor and a BOTA member, and he ended up migrating up to Tampa and really kind of reshifting his focus as a professional to handle more of those claims as opposed to the BI and the liability stuff. So I'm sure I'm leaving out an awful lot. You're a father, you're a husband, and you're an overall good guy. But with that being said, Sean, thanks for joining us today.
Hey guys, thank you for having me. I've seen your podcast for some time, and you put out some great content, and you guys put out a lot of great content on LinkedIn otherwise. And so I think there's a perspective here that I've kind of picked up on when I'm working with claims examiners or TPAs on a commercial claim. And it is different because I remember, starting out as a young associate, you work with 20 different insurance carriers and you report to all these carriers and claims examiners. And, they kind of have, they may have a stable of 500 cases and it's all the same case. And so they kind of just get wedged into how they handle them. But with the commercial stuff, it kind of was almost like a curveball to them. And then sometimes it's frustrating and it makes the case so much more expensive to litigate on both sides. But it's interesting, I think, the contrast and kind of your experience that you guys have had, litigating just, big, high value cases, high exposure cases, and then the same kind of pushback and delay and things that you deal with on what are obvious, quick, simple cases that you shouldn't have to spend 2 years litigating to get that $50,000 settlement. So I think there's probably some, go on.
Well, no, I was going to say that last comment you made is something I kind of want to drill down on, which is like, as a plaintiff's lawyer, we often find ourselves in cases being litigated when we thought pre-suit should have been sufficient, or now we're knee deep in litigation, gearing up for trial when we thought it should have been mediated and resolved. And so I want to just kind of hit the pause button and talk a little bit about I'm going to oversimplify it, just call it the claims handling process in a bodily injury or wrongful death claim. So, John and I have talked at length about what it feels like to experience it representing the claimant. But can you shed a little bit light on just generally how the claims process works, the role of the insurer, the role of the defendant that's actually being sued, the role of the defense attorney, and then you mentioned TPA, third-party administrators, how they come in and out?
Yeah, no, that's a great question. So when you have a commercial claim, not all of them are going to be covered by insurance coverage. So, if you've got construction defects, a lot of times you're representing, sometimes I'll represent a homeowner who's, built a nice home. And unfortunately, they hired the wrong contractor who's defrauded them, who's stolen money from them and the like. So, in those types of instances, insurance is going to play a smaller role because it's likely that you're not going to be able to find coverage. But where you have, maybe just it was a small case we had recently. Basically, contractor hired to install flooring in a showroom and just, installed really crappy flooring, was starting to bubble up all over the place. So we probably spent 6 months in pre-suit trying to say, like, look, this is obviously the work was terrible. We haven't done anything. And, our client hasn't stepped into the showroom since the flooring was installed. This is clearly, breaching the warranty. You guys need to come and fix this. So insurance carrier got involved, a couple early letters exchanged, because, sometimes you get very quick responses because what are they going to fight for 2 years when they know they're not only going to have an attorney's fees potentially hitting them because it's, we got a contract in place that has an attorney's fees provision. But in that particular instance, we got, it was about 6 months of just kind of screwing around with the insurance carrier before that we just realized that we have to sue them. But then once you've got the subcontractors that got involved, their insurance carrier gets involved. 2 months after that, you have pretty much a settlement. And so sometimes it takes, with commercial claims, it takes that lawsuit, it takes filing the actual suit to really put the fire under them. And I know you've probably, you see the same thing with the PI stuff as well. But so that's kind of the most typical. You oftentimes have issues where there's no coverage. Well, you do have coverage, and it's clearly something. Maybe it's negligence against a contractor or something, or something that would you'd have coverage for. The issue that I often see with the claims examiners and insurance coming into place is that they just don't understand the claims, and they don't see a wild factor in the claim. They just see, okay, my client, damaged your home or whatever. I'll keep it simple. Contractor damages the neighbor's house, negligence, there's no contract. So you got tort, but you're not going to have in those cases, non-economic damages. Rarely going to have punitives at play. And so the claims examiners just see it as a straight accounting issue and say, okay, well, your max damage is 20,000. So if you're not going to take 10,000, we'll just let it litigate. And so you can oftentimes have trouble showing and highlighting for claims examiners how obvious their liability is for the insured, because they don't see the fire of non-economics, those wild cards that they can't quantify. They can kind of guess, what their exposure might be, but without those, wild factors, sometimes you see real deliberate foot dragging and delaying because they kind of have an idea of what the number is, and they just, rather play the numbers game.
That's interesting you mentioned that because, as I was sitting here, I'm thinking, if there's a quantifiable amount of what you can get, say for instance, if we had a claim where we can only bring a claim for medical bills, we know what the medical bills are.
Yeah.
They have their max day. They know that, with the exception of potentially if you've got a fee provision or the award of costs, you might have that. But, so does that change? Obviously, it changes settlement negotiations, but then does that change kind of your approach? Are you looking to try to make claims for punitives, try to get some of those? I mean, obviously, I'm sure you are, but in terms to add some of those wild or wow factors that you described to kind of help those cases? Yeah.
So we had a case. It was a securities fraud case. And it was a challenging case establishing liability against one of the defendants. So just to kind of simplify it, there were district courts in other parts of the country that have said that this particular type of defendant just wouldn't be liable in a securities fraud scheme. Just unfortunately, that was the case. There was just they had a certain distance from the transaction that they could say, yeah, we didn't know anything about it. So in those types of cases, you're trying to, with securities fraud, you're trying to find the enablers, the facilitators, because typically fraudsters, they know the money's gone, and once they get it, it's gone. It's very difficult to collect against them. So you always have to look for, well, who helped you get the money in the first place? Who facilitated, who enabled you? And so with these types of cases, you have to be very aggressive and a lot of pressure, because, if you can loop in a financial institution into the lawsuit, to show, hey, look, you're, for instance, and give you more facts, for instance. So we had a case where the client got sucked into this fraudulent investment scheme. And the way the fraudsters were able to perpetuate the scheme was using a third-party administrator, basically, not in the insurance context, but a third-party administrator to kind of rubber stamp all the paperwork that they would send the investors. And so, we focused on, hey, you had enough information that you knew that these fraudsters were running the scheme, and you never notified the investors. And so, while the law might have ultimately been on their side, we had to keep putting pressure, move to add punitives so that they would ultimately come forward with what was, a substantial six-figure settlement. But that was, 3-4 years into the litigation before they finally decided to put, real dollars on paper. And so sometimes with these commercial claims, like, with the PI stuff too, but with the commercial claims, you have to be pretty aggressive because of the fact that if you don't put a fire under them and you just let it sail its course, you're not paying attention. You're not really making the other side put attention and put time into the case every week and litigate it. Then they'll just let it sail and let it go down the road. But those are the kind of things where you've got commercial claims and you have to be creative in your approach. You need to kind of be slightly overly aggressive. Because, with contingency, look, you have a simple case, you don't want to go before the judge 10 times before you get to trial. That doesn't help you to spend all this time and money in the case if you don't have to. If you can go before the court a couple times in litigating and then get for a jury, that's right. That's the ideal situation and on a bodily claim. But the commercial stuff, you're going to have to not only affirmatively fight, but you're going to have to just assume that they're going to fight twice as hard, because they've got a big institution, and maybe they're not paying insurance rates. Maybe they're paying, regular market rates. And so you don't have the same, insurance defense restrictions on, the way cases get defended. in the commercial side. So you do necessarily have to be sensitive to how the other side's going to approach the case as well, and the resources that they're willing to dump into it.
Well, I'm assuming, let me just say, because I'm over here taking notes. This is like my university, Sean. You didn't even know that. But there's like so many points of interesting crossover that I want to know, like, where is the line where it becomes dissimilar? So from a case selection standpoint, as a commercial litigator, I'm assuming that one of the concerns you have, just like we would in the plaintiff personal injury realm, is whether or not there's going to be coverage, and if so, if it's going to be adequate. But then it sounds like there's also that secondary similarity, which is like, okay, let's assume there's coverage. What kind of claims are we bringing here? Because if we're bringing fraud, we know there's going to be a fraud exception built into the insurance policy. And so now are we kind of in a situation where we're almost manufacturing, if not manifesting, a situation where there won't be coverage to collect? Are those the kinds of things you're considering on the selection process up front?
Not only on the selection process, but also on the claim selection process. So, personally, while I do have cases where, the client, look, they've been defrauded, and there may be very little hope to recover against the fraudster, but the client says, look, I've been wronged and I want a judgment against them. I don't collect tomorrow, but look, I've got decades before I can keep going after them. And so there's those cases where clients made the decision, I'll put the money into this, you getting me going after them, exposing the fraud, finding the judge, getting me a judgment. And look, if we don't collect in a year, 2 years, that's fine, because I've got time to go after them. So that's certainly, you have those types of cases. And then you've got cases where, look, these guys did something bad. They committed fraud against you, but do we want to drop the F word? Because that does affect coverage. That will affect the ability to get third parties who might actually pay for the liability. And so those are certainly things where, look, there's fraud, absolutely, but we can come short of fraud, but still potentially have coverage, or we can, still have the theme of fraud without, overtly asserting it. So there are cases where, you might just want to go with a, breach of contract claim, something simple, where you might have evidence and you might have an exception to the contract to assert a fraud claim. There's certainly going to be times where, hey, if we do this, we got to make sure that the company itself is collectible, because, their insurance coverage, you're just not going to have any. And
Right.
So those are certainly things that, just like, you would when you're evaluating a case, like, hey, do I want to go sue this business owner because, hey, he's got no policy in place and it looks like, he barely has a can to piss in. So the question is, those same considerations will definitely come up.
Well,
not only
for us, when we get to that situation, we see that there's no policy available on the other side. It's a deal breaker, like almost universally true. And it has to be, because our objective, we measure wins by collectability, how much we actually net in our pockets favor. There's no such thing as paper justice for us. Whereas with you, at least it's conceivably true that the client could be, adequately capitalized, like you just said, and tell you, look, I don't mind. I'm going to pay you anyway, work hourly, get that judgment. I'll deal with collecting later. So that's an interesting distinction. But it does sound like the fraud and the voiding coverage is definitely a similarity. Let me ask you this, because from the beginning of your career, plaintiffs' personal injury attorneys, we don't get attorney's fees unless we find a way to create them, right? There's no contract provision that says, hey, prevailing party, automatic, you get attorney's fees from inception. So our number one tool to even make that a potential option is still contingent in the proposal for settlement, a creature of statute and rule under Florida law. Yeah. And Georgia law has the same stuff. So for you, though, in most of your cases in commercial dealings, are you seeing prevailing party attorney's fees provisions in almost every contract that's there's a dispute over? So if anybody put more than $8 into the contract to prepare it, there should be an attorney's fees provision with most commercial contracts. If you have if you're high, any sizable contract, there should be an attorney's fees provision, unless it's just a straight consumer transaction. But if you're hiring a contractor to build a house for you, you're hiring anybody to do anything significant improvements to your home, other than just delivering a refrigerator, you want to have those protections as a consumer, but also just as somebody who's, even if you're not a consumer, if you're the business owner, you want to have those protections. And so, most of my cases, we either look for, we look for it in the contract, but we also look for a statutory basis, because there could be a claim that could be brought where you have a prevailing party attorney's fees provision. For instance, we had a case where we took a case over from another firm. Two competing security companies. They both provided private security officers. So company 2 decided to rip off the trademark of company A, our client, by setting up all these fake website domains that just mimicked the name of our client. And so there were
7 or 8 claims that were brought against the defendant. And so when we took the case over, we realized there's just too many claims. Like, you don't need, you can just do one claim pretty much under the trademark law, and you can tag them for cyber squatting, and then that'll give you your attorney's fees, that'll give you disgorgement, that'll give you everything. I think this is just a separate point. I think a lot of times commercial litigators, when they're figuring out how to best approach a case, they assert too many claims, and then they end up tripping themselves over, because you don't want to assert a claim that you may not ultimately win on if it could confer a prevailing party status to the other side. And so sometimes when you've got, especially in the commercial side, I see this all the time, more is not always better. Like, if you can prove it all, and you look at the jury instructions and you look at the evidence before you file suit, and you say, look, we can prove our case under this, we can get attorney's fees, we can get costs, we can get whatever measure of damages. Don't bring the 5 other similar claims that
That's
only
fascinating.
could,
John, I'm sitting here thinking about it, like, because when you and I are coming up, part of the value add, we hope at least, if a client chooses our law firm, is that if we have to litigate, John and I and our team are creative and experienced enough to identify all of the conceivable causes of action, because there's very little risk in over pleading and abandoning later. Whereas with you guys, you have to almost do that screening process before filing.
So I'll give you a great example. So this case that I was talking about, there were about 7 or 8 claims brought. There was the claim for, the primary claim, which was all you needed, was the trademark infringement. But then they brought companion claims for violation of FDUPTA, Florida Deceptive Unfair Trade Practices Act, misleading advertising, another statutory claim. They brought maybe some other equitable claim. But the point was that there was 3 different claims under which attorney's fees could be had. And so what happens if you win one, but then you lose the other? Because they're not all the identical elements of proof and elements. Some were slightly different. And then when we took the case over, we started looking at, well, what do you need to actually prove the misleading advertising and the FDUPTA? It wasn't as easy as the trademark claim. And in fact, it was harder, such that we actually had to kind of abandon those claims. But then we had to fight with the other side over, hey, does this confer you prevailing party for a status, or does it confer us? Because we won on the main trademark claim. Now we got lucky in that case, because there was a great opinion by Judge Altman out of the Southern District that provided that case. Said, you look past voluntary dismissals to determine prevailing party status. Look, they won on the main claim and got everything they wanted. So them just kind of dispensing with these unnecessary claims doesn't all of a sudden now flip it upside down.
It's kind of like, get to the heart of the matter, and let's not.
But nevertheless, that was a fine line. But there are instances where people will just assert 5 or 6 statutory claims, think they're covered, and then they lose on a couple, win on a couple, and then the court's in this situation where, well, you're not going to get all your attorney's fees back. I mean, you may get those for prosecuting that, but you're going to take a huge hit on all the fees that both of you incurred in fighting this other claim. And so sometimes, with more claims is not being better, you may end up getting hit on the attorney's fees if you ultimately do prevail.
Well, John loves keeping track of his time and keeping meticulous time records. So I can just imagine, well, John, you should do commercial lit so you can parse out which hours went to which claim, man. You'd be assured.
You try not to do that, because you want it to be inextricably intertwined. If you do parse it out, you almost kind of shoot yourself in the foot. But it's kind of like a blessing and a curse, because then you show what you did for that particular claim, and you can cut it away if it goes south. But if the court says, well, you won generally, then you just say, oh, it was all inextricably intertwined, and then
right.
But you can certainly lose on that argument as well.
One of the questions I had just written down before coming in, because John and I, we like to pride ourselves on being jury whisperers. I mean, I'm being sarcastic a little bit, but I mean, jury trials is what we're all about. If the other side gives us an opportunity to walk into court and impanel 6 people and convince them, that's what we want to do. That's an upside. Yeah. But with you, I'm assuming a lot of the times there's like contractual waivers of jury trial provisions and all of that. So that's a totally different territory for me. When I was a public defender, I was in the divisions where it was still jury trials. I didn't do juvenile with bench. So I have no experience with that. The closest I've ever gotten are Daubert hearings and summary judgment hearings. I guess summary judgment's closer. Can you talk a little bit about not just the differences between the two logistically, but strategically, how you're going in all the way from opening statement, exhibits you're going to use, witnesses you're going to call, et cetera?
So yeah, typically, so with our practice, we not only, with your breach of contract claims, those are where you're typically going to run into the jury trial waivers and the like. We also bring a good deal of just general commercial claims. And so we do get a lot of claims where there's no jury trial waiver. We have a jury trial at the end of this month down in the Keys. We had a non-solicitation jury trial last year in Pinellas County. It was a business tour, and I think there actually might have been a jury trial waiver in that contract, but we still did a jury trial demand, and the defendant failed to object, and so we ended up going with the jury trial. So sometimes, even if you do have a jury trial waiver, we will always demand a jury trial regardless, and then put it on the other side to object. Because if they don't object, then they waive that waiver basically,
Sure.
right? So we always try to go for a jury trial. When you do have a bench trial, the biggest consideration is that you have to now realize who your trier of fact is, who's deciding your case, who's deciding your facts, and that's the judge, obviously. And so that FaceTime with the judge is that much more important in advance of a hearing, whether it be on an injunction hearing or on a bench trial. That FaceTime before, and kind of getting the issues before the court, not in a frivolous way, but where you have the opportunity in the case management conference, in pre-trial briefing or pre-bench trial briefing, and if there's discovery motions that have merit. Those are the instances where, conditioning the judge and getting before the judge and kind of previewing the case and what the issues are can really help, at the end of the day when the judge has, some judges will have non-jury bench trial periods that I've seen. I think in South Florida, there were a couple that had that. Other times you get kind of unlucky and you may get, day one will be on this day, and then a month later you'll have the second day of the non-jury trial. And so sometimes you may have a 3-day non-jury trial spread out over 2 months, which is obviously not ideal. It's like trying to have a phone call summary judgment hearing. You can imagine, no matter how smart the judge is, they're going to have that gap in time. They're going to
still human
naturally,
after all,
Exactly. You could have the smartest judge in the Southern District of Florida, and they're just naturally going to, forget some stuff. So that's why it's important to make sure you do, that pretrial briefing, that bench briefing is really critical, because you want to make sure you've laid out everything clearly and concisely, so that the judge, if you do have situations where you're not getting all that bench trial time together, the judge is going to be able to just pull up your brief and easily read what the issues are. And then of course, I've had cases where, you start day one, and then, you might not go before the judge on day 2 or 3 for a few months. And so you got to make sure that you supplemented, you provided some supplemental briefing, to the other side. A lot of attorneys won't. A lot of attorneys will, not take the initiative to kind of refresh the court. And so it's an opportunity to give the court some supplemental briefing and just kind of remind them where they are, give them a summary of the testimony that has been presented, that, if there were witnesses in that first day. So these are the kinds of things that you want to think about in the presentation. And you also just want to make sure that the actual presentation is even that much more memorable to the court. And so that's why it's important that, if you just have a straight 1-day bench trial, judges generally don't want the flavor when it comes to presentation, examination. Look, if you've got a bad witness that's going up there and you're going to cross them, make them look bad, absolutely. But they're not going to, and you'll see their face and you'll see their reaction. They don't need the big grandiose opening. Oftentimes they'll limit it. Now, if they sense you're a good public speaker, they'll likely just want to hear it anyway. I've noticed sometimes, if you take the approach and you're kind of dry and when you start with these judges and you ask them, Judge, do you want opening? They'll likely just say, just give me a brief opening. But if you give them an opportunity to say and to see that this might be a good advocate, coming up before them, then you'll get that opportunity. But generally speaking, they usually cut back on openings. They'll sometimes have written closings. So that's why, bench trials can be great because they can be cost effective, but you have to be able to really tailor your presentation based on the limitations you're going to have, which is, like I said, those time gaps and the fact that the judges, you kind of have to make your presentation tailored to that specific judge. And so that pre-trial FaceTime and understanding what the judge likes, what the judge doesn't like is critical. Because you've been before judges, I'm sure, Jordan and John, where you go before the hearing and you think you've got a slam dunk motion, and the judge, you go there and the judge just says, go on, present your argument. And then you get to the end and they had no questions for you. You have no idea how they're going to rule. You could just flip a coin as to how stoic they are. And so sometimes, you have to, if that's the case, you have to, adjust accordingly. But if it's a judge who likes a little animation, likes a little color in the argument and in the presentation, certainly, take advantage of that and use that to your advantage.
Yeah, I think that knowing your audience is an important thing. And I've actually never, when you talked about, I was sitting here when you were talking about written closings,
Oh yeah, they're there. Yeah.
That to me, because the problem is some people write out their closings. I mean, look, different trial lawyers say different things. They're like, write out your closing 6 months before trial, all this. And I'm like, closings to me is such a fluid process because I don't know what evidence is coming in yet. I don't know what's going to play out. What's my important things until closing. And so the idea of writing a closing, I don't think in my last, I think I've tried 25 trial now. I haven't written a closing do I have a general outline of what I want to do? And, yes. And is it building my PowerPoint presentation? Is that kind of like my writing my closing? Yes. Mm-hmm. If I had to present that to the judge, and you guys do a lot of like findings of law and conclusions of fact, or no, conclusions of law, excuse me.
Yeah.
Submit those. And you do those before, I guess, and after. So, but I've seen, I think some people get afraid of bench trials. Mm-hmm. And I've seen some of the big trial lawyers out, for instance, out in California. I mean, they had a judge give $23 million on a case.
Wow.
And it was they did the presentation. He did, the judge actually had questions during their closing and opening of questions they had in their mind that they were answered. And, so I think that judges want to do the right thing. And to your point, if you present it well and you're a good advocate and they want to hear from you, they're going to want to hear from you. So
I'll give you just to piggyback on that. So with the bench trials, so typically, following the bench trial, court will want it, written, opinions of fact or conclusions of law and findings of fact. We had a case and it is, because people do, as a plaintiff's attorney, you generally stay away from federal, federal court's not my first go-to. I don't wake up and say, oh, let me file this in federal court. I prefer state court. That's kind of the way I learn. That's what I prefer. But when you are in federal court, obviously, things are a little bit more serious. I mean, that's the way I think they kind of hammer it in law school and in practice. Things are a little bit more serious. You've got tighter deadlines. And sometimes attorneys and practitioners just think, okay, well, then the judges are just less fun and they're more serious. But, we had a bench trial before Judge Cannon. It was that trademark case. We got summary judgment on liability. We got summary judgment on attorney's fees. So we were going into this bench trial just on damages. And we already had, a substantial attorney's fees award in our favor. We already established liability. And so the question was presenting the case in a way that was persuasive on damages. And our damages were disgorgement. So basically they had set up these fake websites, and the law provided it's a very unforgiving mechanism under the trademark law, but it provides for disgorgement in favor of the trademark holder. And so what we have to do as a trademark holder is just put forth all the sales the infringer had during the infringing period. And then it's the burden of the infringer to show what sales were not related to the infringement. And so with that, it's equitable, it's a bench trial, it's disgorgement. And so the court has to basically come up with a number based on the evidence presented. That's, what's ultimately going to be fair in light of it. And so what's unique about it is you don't have to have any actual damages. And so our client we couldn't prove a single loss of customer or anything. So, but we needed to present this case in a way that was exciting and flavorful, and not just about a case where, hey, judge, technically they violated the statute, even though we can't show actual damages. We want you to give us substantial disgorgement. So please. So we had to make sure we showed how much these guys on the other side hated our clients. And so when we were presenting them before the court, we were pulling up text messages, emails that they had sent internally that we got in production, where they were basically implying that they wanted to kill our clients because they had a feud with our clients. And so all this bad karma, and I won't say it all on the podcast, but they wanted to, horrible things they were putting in writing and text messages that we got back through forensic searches. And then the court, so as the court's seeing this is turning from just a simple, a technical violation of a trademark law to this was a scheme by these guys. They planned this for months. They purchased these registrations. They wanted, this was only one prong in a multi-pronged attack on my client. And so the court ultimately, even though we had no actual damages, the court awarded us a 7-figure disgorgement award. And so we ended up.
But that story tells me something, which is that I'm guilty of this, like probably more than most. I want to talk about trial as often as I can do it with anybody that wants to do it with me. But the truth is, every trial is just the end product of meaningful discovery. And if you can't, propound discovery well and force the other side to comply and get at what the true evidence is, you end up hamstringing yourself when you go to trial, because probably if you and your colleagues hadn't done a good job in discovery, you wouldn't have had those messages. And it reminds me of a case John and I handled. It was a tragic case no matter what.
Mm-hmm.
But it was a car crash where one of the person, the patriarch of the family died. The adult son was pretty badly injured orthopedically. Tragic case anyway.
Mm-hmm.
We would have done well. We kept digging and digging because something just stuck in my head. Like, this crash makes no sense. It happened on Christmas Day. Why was this kid even on the road? Why did he blow a light? Nobody else was out there.
Mm-hmm.
Anyway, we kept digging. We forensically examined his cell phone. Turns up he was looking up prostitutes while he was driving on Christmas Day.
Oh.
That case went from tragic to the insurer stepping in and paying multiple policy limits to make it go away. And it made a significant impact for the family that they otherwise wouldn't have had.
That's a great outcome, yeah.
Can you talk a little bit about your approach to discovery? Because, John and I, you commented on this earlier, we're contingency based. So we want to be as effective but as efficient as possible with our time. Whereas you don't necessarily, efficiency is always going to be something that's celebrated, but it's not maybe the main driver. So what's your approach to discovery?
So we take, I don't want to call it a team approach, but we take a we'll have several people look at this because we don't want to send, every time you send discovery, you lose a substantial amount of time. You not only lose 30 days in the response, but you also have to account for extensions. And we want to go to trial as quickly as possible. We want to because if we don't get a trial order and put a trial date, then we don't have that additional pressure on the other side. And so when you have tight discovery periods, we don't like to just, sometimes it's easy to say, oh, just send it out. And if we don't get back what we're looking for, we'll just send another request. But that's all time that we end up losing. And so we don't want to go and ask the court. Our approach is to almost never us affirmatively ask for extensions on discovery. I mean, we'll grant them to the other side, but we don't want to be in front of the court, telling the court, hey, judge, we're ready to go to trial. And then the other side says, well, judge, they've asked for like 8 extensions on discovery. So they're clearly not ready. So that's number one. When we're preparing discovery, we always really want to make sure that we've looked at it, we've thought about it. And I don't mean spending a week, sitting around deliberating, but making sure that, and we use the same definitions and instructions across all our cases firm wide. So, these are tested. We've been before multiple judges and multiple jurisdictions.
Let me ask you, are there standard form ROGs for commercial disputes? Like in Florida, as you know, in the appendices to the rules of procedure, there's some Florida Supreme Court approved ones.
No, you get to do your own. You have to, craft your own. You can obviously model after the basic ones, who prepared these and name witnesses and the like. But we try to avoid sending the generic, who are your expert witnesses going to, 5 days after the lawsuit started, because you know what they're going to respond. Right. And so we always try to, we take, we don't necessarily, depending on the case, we're not going to go out and send 70 different questions for the sake of sending 70 requests for production. But generally, in our experience has been, you never really need more than 20 or 30 in the entire case to get what you need, to get what the other side has to prove, or what the other side is going to try to rely on to defend. And that's pretty much the approach as far as, how we go about it. We always try to make sure we get everything in native format, absolutely, or with load files so that we can put it into our own third-party vendor so that we can run searches, organize it accordingly. If we have a case where we know there's going to be a lot of emails, obviously we don't want PDFs because that's just, we can't organize it. We don't, there's not going to be, we're not going to know who might have been carbon copied or BCC'd on it. And so we try to make sure, and we put that in all of our requests, give us the native native format, load files, all this, that, and the other, so that we can efficiently look at it and review it. Because we'll get cases, on the commercial side, you get a big firm on the other side, and they want to just dump you with 10,000 pages of documents, 15, whatever it might be. And that takes a lot of time. And so it's important to make sure that, your requests are, you're asking for the native production, you're complying with the rules. They have an obligation to provide it in that format. And so that you're getting it back in a way that you can not spend days and days, if not weeks, going through their production to find. And it's typically the way it is. 3 or 4 good emails are buried in 10,000. Right. And that's just the way the defense works oftentimes.
Do you have any experience? Well, I'm sure you have some experience, but I mean, how extensive are you being forced to do binding ADR, like mediations and arbitrations, as opposed to going to trial? So like for us, we get a trial date and every trial order says you got to at least go to mediation first. So we're just used to it, but we can always impasse and go to trial. Very rarely are we dealing with a tort case with some mandatory arbitration. Mm-hmm. For you, can you kind of explain how common it is and if, what your approach to those are?
It's not that common. My colleagues though had a case. It was before Judge Acharte down in Miami, and it was a insurance company breached a title policy, and it cost the client was seeking about $2 million as a result of this breach, or after their failure to pay. So to save you all the facts and the long explanation, so it's before Acharte. He ordered it to non-binding arbitration. I think that was the first time in 5 years of doing commercial litigation I'd ever seen a commercial claim actually get referred to non-binding arbitration. So my colleagues were handling it. They went before Judge Reyes, mediator Judge Reyes, ruled in our favor, and ended up settling in our favor. But that was the first time that I think I had seen it. So it's not that common for the non-binding arbitration. I think even Judge Acharte was kind of, might have been something that he didn't typically refer to.
Oh, it's a tool in their tool belt. I mean, technically, every judge could send any kind of case to NBA, and when they do, our firm actually we have a constitutional challenge to that because there's a fee shifting mechanism tied.
Correct. Yeah. If you don't accept it, correct. Yeah. So that was the first time. I mean, that was the first time. Otherwise, you have your standard mediation requirements, and I think the big thing that one point that I haven't touched upon, but I think it kind of goes towards something that George, you and I talked about, or maybe commented on LinkedIn a few months ago, was that when you have if your claim, if you have a commercial claim and it gets picked up by insurance counsel, something that I've seen, and we go against a lot of the same big insurance defense firms in Florida too. And there's one firm in particular, I won't say who they are, but it doesn't matter what the claim is, if it goes to them, it's just like exponentially harder to litigate. And it's because the attorneys that get assigned to it, it's out of their wheelhouse. And so it may be like the one claim that they have among like 70 other slip and fall cases. And then with commercial claims, it's just, you can't, if you have a straight negligence claim, the negligence law. And so the only time you're really going to come up with research issues, or if you've got like subsequent tortfeasor issues, concurrent, causation issues, expert issues, like that's where your research is going to be in a negligence. Like nobody, how often do you ever come across a motion to dismiss on the elements in a negligence case? I don't think I ever filed. Never. Yeah. I filed one motion to dismiss as an insurance defense attorney, but it was on a commercial claim and we won regardless. But point is, you just don't waste, the defendants don't. But on the commercial side, not only you see these kind of frivolous motions to dismiss because they think, oh, well, maybe it's a little bit different, so maybe there is a chance on a motion to dismiss. You'll get 5 times as many affirmative defenses that don't even make sense. We almost always deal with them because it's you can get them dealt with in a quick hearing. What else? And then I think the biggest thing is you get impediments to settlement because the carriers, the claims examiners that are assigned, or if it's a TPA, they don't typically deal with types of claims you might be bringing. With the only exception is going to be when you have like a construction defect, carrier, and they've got a CD examiner who kind of deals with those types of claims regularly. But if you have just like a fraud claim, a tortious interference claim, some breach of contract, and it gets picked up by insurance, they typically have
general liability adjuster's desk.
They generally don't understand the substantive law, so they're not, and then oftentimes the attorneys don't either, and so they kind of so it's kind of like the blind leading the blind. They kind of think that they've got great defenses when they really don't. I mean, we had this case, just an obvious breach of contract. Our client had been fired and the contract provided that you couldn't take the employees that we had trained to work on your site. So they fire us and then go and hire all of our people. And so we've lost all this money we had spent in training these people when we were going to just reassign them to another facility. And so we're like, hey, we're talking to the carrier and multiple settlements. And it's just like, they think that they're bulletproof. There's just no way. And the law that they're being advised on is just the wrong law. And so we end up going to, we're at jury instruction time, charge conference, and they had previously pled like 10 affirmative defenses. So we're looking at jury instructions. We've got ours ready, and they don't have a single instruction on an affirmative defense they want to put forward. So we're like, wow. So all that time we fought and denied, and all this time we dealt with, even if it was just a couple of responses to pleadings and stuff, like you still asserted all these defenses. We had to operate under the assumption you were going to board all these defenses. And now here we are with jury instructions, and you haven't even bothered to write any of them up. And so now they're all gone. And so
John, we're not the only ones who are frustrated by, I'll say, bizarre defense tactics.
No, we all deal with them, just in a different context. But they try to deny, delay, don't pay. I think that's a universal approach to many aspects of the law. At least from the defense side.
Can I ask you a question about how you got into this? Because this is like for me, it's always a unique question, or it's always a unique answer, obviously, because everybody's different. But for me, I went to law school as a second career. When I finally decided to do it, I had committed in my mind I wanted to be a trial lawyer. I thought criminal defense was the end all be all. And I found a natural migration to PI thanks to John, because I'm still helping people. I'm still the underdog, etc. But when I was in law school, nobody talked about PI. Plaintiff for defense, really. I mean, I knew insurance defense clerk opportunities, but it wasn't talked about. It was all either clerkships or like big commercial defense firms. How did you find your way, like from a passion standpoint, to doing the plaintiff side of commercial litigation?
So I started with my first firm out of law school, and I think you're right. I think a lot of law school, and it's something that I've also kind of commented on too. I think, you go to law school, if you go to any larger law school, you kind of get pushed and I think conditioned that, the best job is going to be at the biggest firm. Like, you want to go to big law, and that's not the case. You don't, with the hours and then the ability to generate business and kind of make yourself. It's a huge give and take. So me personally, I just, in law school, I naturally found this firm where I was first working at doing insurance defense. I worked with this phenomenal defense attorney, longtime ABOTA member. Plaintiff's attorneys that I had spoken to in law school were like, yeah, Sonny's phenomenal. He knows, he can try anything. I mean, really top tier. And so I said, yeah, let me learn from him. So I worked with Sonny Myers for a few years, had a great practice there. And then, but I didn't like defending companies. I didn't like defending these injury claims, even though they came, and what I appreciated from where I worked was, look, we didn't assert frivolous defenses. Look, if it was a case where we were going to lose, I mean, we were certain to advise the carrier accordingly and look, you don't want to take this to trial because you're going to get hit a lot harder. So you have an opportunity now. And so that was the approach that I always had with the cases. I never wanted to say, I was never let's just throw up roadblocks. I would always want to have that honest conversation because I didn't want to fight and I didn't like losing. I don't like losing. And so I didn't want to tell a carrier to keep fighting a case when I knew ultimately we were going to have to pay. I didn't want to be on the losing side. And my boss he knew when to hold them and when to fold them. And so I kind of appreciated that. But I didn't like defending cases. I didn't like working for the big companies. It just wasn't for me. I liked suing versus, more so than being sued. And so I had an opportunity to work with this great commercial litigator, Glenn Waldman, and got to, he was a big, another big ABOTA member, had a lot of first year trial experience. And I learned a lot with him as well, got to try several bench trials. And I just kind of naturally fell in when I was with him. It was, he was mainly plaintiff, he leaned more plaintiff side as far as commercial claims. And so that's kind of just the practice that I kind of picked up on. He kind of discouraged me from big law, as well, and about all the control and, the ability to develop business and generate your own claims and also just do the plaintiff side. Because generally the bigger the firm, the harder it is to bring in a plaintiff case, even if it's a commercial case, right? Because you're going to be suing somebody and you're likely going to run into some conflict because some guy in a satellite office 500 miles away spoke to that company 4 years ago and therefore you can't now sue them. And so those are the kind of things that kind of shifted me towards a plaintiff sided focus on the commercial and business stuff, was just the ability to help people. And like I said, and like I've kind of hinted on, that the typical client that I have is someone who's been defrauded, been wronged, or otherwise been injured by some business or some other individual.
And what's the best way? I mean, you're in Tampa. Can you just talk about, for the listeners out there who might be interested, maybe even need your help, what's your geographical scope of reach and what's the best way of getting in contact with you?
So we focus throughout the country. I've litigated everywhere from Las Vegas to Monroe County. I mean, currently I have clients in Santa Rosa County, Florida, and all the way to Monroe County, which is where this trial is going to happen next month. And we've taken on cases in Georgia. I have a legal malpractice case that we're currently litigating in the Northern District of Georgia on the plaintiff side. But we have a regional reach, but we focus mainly within the state of Florida. But for certain cases, where it makes sense and we can partner with the right firm, we'll go outside to the Southeast region.
Awesome. I feel like we got to do this again, man. I enjoyed it.
Yeah, I think so. I think there's certainly more areas that we can kind of focus on and more kind of threads we can kind of unravel and kind of help each other with, things that I've seen. And I talk to a lot of plaintiffs attorneys that a lot of my friends that I went to law school with are plaintiffs attorneys. And so I'm always picking their brain, like, hey, what are you seeing lately with claims examiners? What are you seeing? Like, what are the responses you're getting? And funny enough, one of the things that my buddy was telling me was that now with the new, with the shift towards modified comparative fault, he's now seeing a lot more pushback from carriers saying, well, we think your client might have been 52, 53,
Right.
54, whatever it might be. So whereas like he might have been able to get an early conversation going, he's now starting to see these kind of like, carriers, taking, just copying the language from the new bill.
Yeah, Justin's listening. He's going to take a note. We're definitely going to check back in, and you wouldn't be the first recurring guest, but I think you've got a lot of value to add, a lot of interesting perspective to share. And
I appreciate it.
John and I can only offer what we know, and we don't know what people know. And it doesn't hurt that you're a Kane, so we know you're top of the shelf. With that being said, John, unless you have anything else, I see you're wearing a tie today, which means you must have a hearing somewhere. So
something important, yeah.
Time for business.
I've already had hearing depot, and I got another account to call and hearing coming up that I got set.
All right, I want to thank everybody for listening to this episode of the On Justice podcast, and give a special shout out to Sean McCleary for joining us today, taking time out of his busy schedule. So for those of you that want to find Sean, he's very active on LinkedIn. Just look him up. He's the one and only, at least that I can tell. Otherwise, you can go to his website, which is the firm website of Bartlett Loeb, and his email is on there, is contact information, or just go to the Florida Bar website. So thank you for joining us today. Thank you for the listeners for staying in. And if you have any feedback or comments and you want to hear more the next time Sean's on, just drop some comments. Justin will take notes, and we'll make sure to cover it next time. So that's it for now. Take care.
There's nothing more thrilling than nailing an insurance company.
And the truth shall set you free!
I want the truth. You can't handle the truth.
Great moments are born in great opportunity.